I'm Susan Buckingham. I'm one of the members of the Friends of the Cam steering group, and we're delighted to welcome you all, and particularly Lisa Foster, who will tell us about the implications of some of the English environmental legislation that's been passed since Brexit. And it is, as she's pointed out, and you all probably know, quite a volatile situation. Lisa's a partner at Richard Buxton Solicitors and has long experience of working with councils, environmental groups and communities who are opposing inappropriate development, including its impact on sensitive natural and historic environments. Friends of the Cam was formed to challenge just such inappropriate developments, particularly where they put additional stress on water bodies through over-abstraction and pollution. And there are many of these proposals which are being put forward in and around Cambridge, which the water supply simply cannot cope with, and which habitats and those who depend on them just cannot survive. I'm sure that many of you here now are already involved in some of these campaigns, which Lisa's knowledge and experience can help us fight. And it would be great if you're happy to share those campaigns in the chat. I'm particularly excited to learn that Lisa initially trained as a lawyer in California, because I'm currently reading and being inspired by Erin Brockovich's feisty account of the US national water crisis, and particularly what people like us can do about it. Please post your comments in the chat, any questions you think about along the way. And at the end of Lisa's talk, if you want to ask a question, just press the hand up icon on the Zoom. So again, welcome, Lisa. We really look forward to hearing what you have to say and be inspired by your achievements. So handing over to you.
I'm not opposed if somebody wants to ask me a question en route as well. Can you see my slides?
Yep, perfect.
But it's very nice. And Hannah Brown, who's with us today, was largely responsible for doing it in our office. So we work quite as a team on the work we do and try to cross-pollinate between what I know and what Hannah knows from the work she does. It's been really useful to kind of step back from the day-to-day grind of the casework and look at what's going on post-Brexit, because Brexit had a massive threat to environmental legislation. And I think, I don't want to spoil the headline, but I don't think the government has a clue what it's doing at the moment. So I'll go through what's happened since the Brexit vote, what legislation's come through. I've tried, for my own part, for preparing for this, to knit it together a little bit and try to see the theme. And I think the theme is that there is a huge amount of uncertainty, and we can exploit that, because as long as there's uncertainty, we can argue positions. But the uncertainty also means that the legislative framework we're working in will be called into question post-Brexit. I'm just going to touch at the end of one case where the judge said, well, Brexit or not, you're still subject to the EU legislation. So the lack of progress by the government is quite important in a way, because it keeps in play the legislative framework that we're working in now. So I'll just run through my slides as quickly as possible. So there's our topics. They were really to help me narrate, so I'll read them. So since Brexit, the government's been busy with legislation, but the question is, where are we? So we had the 2018 withdrawal from the European Union Withdrawal Act. You'll maybe have come across that. And then also in 2018, we had something called the 5-year plan for the environment. And then we had Brexit. Then we had the pandemic. So 2021, the government got around to adopting the Environment Act, was passed, and there's some draft regulations to be laid before Parliament last week, or Monday even. In that legislation is something that has been in the National Planning Policy Guidance and the NPPPFs, this thing called a biodiversity net gain calculator. And I'll talk a little bit about that, but I'm not an ecologist. There may be those of you who have greater experience with the calculator and want to talk about that when we have a question session. Then we get the Levelling Up and Regeneration Bill, which has a lot of changes to planning legislation. Then we also get the Office for Environmental Protection, and there was an initial investigation into DEFRA and Ofwat and the EA. That seemed to generate something called the Stormwater Plan, which DEFRA adopted in August. So that is that concern that if you'd have to be living under a rock not to know that people are quite concerned about stormwater discharges into rivers. Following that, we got the retained EU Revocation and Reform Bill. That was September 2022. And then the last thing I'll touch on is just this recent case called Harris. We weren't involved in it, but I just thought I'd try to bring it to your attention for the purposes of illustrating where things are at the moment. So the 2018 Act is intended to repeal the European Communities Act. And the problem we see, and obviously many people who are concerned about environmental legislation saw, well, if we get rid of many of the European laws affecting the environment, what are we going to get? What's going to be the framework for protections of habitats and species? And so that's where things started, is that there's the intent to repeal the European law. It was converted into domestic law, but as I mentioned, there's now the repeal of the European law bill that's come forward. So it is a total state of flux at the moment. And although many of the bills that I'm going to mention in my slides are not yet through Parliament, you know, they're making their way. And I think it's really important that groups like this stay on top of where the legislation is going, so you know what you've got to work with, what tools in your toolbox, and to be able to lobby your MPs and other individuals responsible for making this legislation to make it as strong as possible. So you can see it as an opportunity. In 2018, and I haven't read this document, but it's part of the, somebody's trying to get in. It's part of the, I'll just let her in. It's part of the framework that's been pushed forward. This sounds great, doesn't it? Green future, 25-year plan to improve the environment. And all of this work is a lot of paper coming out of DEFRA. And I'm anxious that oh, somebody's got their mic on. I'm anxious that DEFRA make good all the talk and walk the walk, because I'm worried that it's very easy for civil servants to produce a lot of paper, and we need to see a kind of results-oriented outcome going forward from the endless reams of paper in legislation. Next slide. Why is it not moving forward? Right. Did I go past one? No. Okay. So many of you will have heard about the Environment Act 2021. I've put a link at the bottom of my slide, which Sue is going to be able to circulate, where you can find the explanatory notes. So that's where I went. And it says this, it says the first part of the Act was published as part of a draft Environment, Principles and Governments Bill in 19 December 2018, fulfilling a legal obligation set out in the Withdrawal Act. The measures produced at the time related only to environmental principles and governance, and placing the previous government's 25-year plan on a statutory footing. So that's what I was talking about earlier, about trying to knit together where things are going. So if you open up that explanatory note, there is a very long list of objectives. It covers 2 full pages. A lot of what the objectives relate to are setting targets to ensure that environmental protections are measurable. That's a very governmental approach, isn't it? Let's measure what we've done. It requires long-term targets, in particular in relation to these things called the priority areas of air quality, water, biodiversity, resource efficiency, waste reduction, targets relating to PM2 particles, species abundance, and then they have to have a review of the target and the effectiveness. And I think this is a theme that comes through. There's an awful lot of government administration, but you know, are we going to see the results on the ground as a result of this governmental administration of environmental legislation and reports. They also have to, oh, my colleague Paul's come back. He's probably come off to check something I did. Then they have to adopt something called an environmental improvement plan. And then there's an annual report on the plan. So I fear that it's become a talking shop rather than an action shop of this is what we're going to do. And I'd be interested in other people's experiences or views on that when we get to the end. And then they create this, the Environment Act also creates an Office for Environmental Protection to hold the government to account. And as I said, this is only part of the list, but I mean, you can kind of get the theme that the Environment Act is intended to create some measurable outcomes. I'm just personally quite worried whether we'll get those outcomes at a level that is meaningful and whether the government really has the wherewithal to do the target testing and checking and making sure that things are being done. All right. How come it doesn't want to move to the next slide? Maybe I'll go down here. Will that work?
Yeah.
Oh, good. Okay. One thing that was brought to my attention quite a long time ago was the fact that section, for those of you that know, there's something called the NERC Act duty, or the Section 40 duty, or sometimes known as the biodiversity duty. That comes from a very old piece of legislation, which is the Natural Environment and Rural Communities Act. I think it's 2006, the NERC Act. And the Environment Agency Act makes changes to that duty. Now, that duty was to have regard to. It says that local authority must have regard to the purposes of conserving biodiversity, and includes in relation to flora and fauna, restoring and enhancing a population or habitat. And there were some changes to that duty, which is intended, again, a talking shop, intended to reinforce the role of the local planning authority or the local authority. And it amends the Section 40 to, as it says, to strengthen and improve the duty on public bodies to conserve. It also mandates a net gain in biodiversity through the planning system, requiring a 10% increase in biodiversity after development. That's important because that's a standard, that's a measurable standard. I'm going to cover a case later on. You'll be a bit shocked when you look at where biodiversity net gain is in play, but it is intended to be a substantial increase and a measurable increase. So that's a key provision in the Environment Act, is this mandate to have a net gain in biodiversity and a means of measuring it. So there is a provision in the Environment Act that requires a draft of a statutory instrument or multiple instruments containing regulations that set the targets for those particular priority targets, air quality, species abundance, and those targets needed to be laid before Parliament on Monday. And I hope Paul will chip in if I haven't got this right, because I sent my slides around to the team to check. What happened was, and this is a clip from The Guardian, the government's delayed the introduction of those targets. So the target deadline, or what needed to be laid before Parliament, was on the 31st of October. And on the 28th of October, Therese Coffey announced that they're not going to meet that deadline. Well, I don't know if somebody's going to take the government to court and say, well, you have a legal duty to meet that deadline. You're not going to meet it. But it's pretty disappointing. And I don't think it bodes well, personally, for where things might go on the other areas of legislation that are deemed to be necessary to deal with the gap when the Brexit legislation is sunsetted. So that's why I'm a bit worried. So that was a very quick view of a couple of key provisions in the Environment Act 2021. We then get the Levelling Up and Regeneration Bill, which had its first reading in May and a second reading on the 8th of June. And it was now published, amended on the 20th of October. It's quite interesting to spend the morning listening to Gove defend the bill. And for those of you that have time on your hands, I think it's really interesting to read Hansard and listen to the way the debate went on it in June. You can get the June 22 debate and read through it. I don't know if they're available on YouTube. They might even be available to view, possibly. I mean, he was a master performance, but again, it felt like a talking shop. It didn't feel like there was a genuine commitment to deliver on the aspirations of this legislation. I think we have to see. So there's lots of key provisions that affect planning, and because your group and many of the clients that we work with, they get engaged environmental issues through planning decisions often. I thought I'd just introduce, this is really just headline stuff, some of the changes that could come through the Levelling Up Bill. So one of them is changes to the local plan making regulations. Sorry, I want to go back. I didn't mean to do that. Why can I get rid of this? Yeah, plan making regulations and objectives. Another introduction is national development management policies, and the way planning matters are decided to ensure that these national development management policies are given effect and have teeth. There's a new infrastructure levy, and this is interesting because I attended a talk somewhere at Cambridge University by a group of developers who were pretty frank and honest that they have a kind of business model that banks consents, and then they don't build out those consents. So there's this constant banging the drum of a lack of 5-year housing land supply by developers. So the Levelling Up Bill, and in the Gove committee discussion, when the bill was discussed, there was a promise to address this concern of developers banking consents and then exploiting the lack of building out those consents to seek more speculative development consents. That would be a huge game changer, and especially in the work we do, because so often clients come to us and say, they're building on my green belt, they're building in my ONB, they're building in sensitive landscape, and they're getting away with it because the councils are persuaded that they don't have a lack of the 5-year housing land supply, even if they don't engage in something called the tilted balance, which means in certain cases, you have to give extra weight to the fact that the council doesn't have a 5-year land supply. One of the provisions, I don't know if I put it in my slides, I might repeat myself, but I'll just tell it now. They're going to get rid of the 5-year housing land supply requirement. Now that is a very big change to the plan making system, but they're going to introduce alternatives to that specific requirement, which is to require that the plan is up to date. In other words, it's been made in 5 years. But those of you that have been engaged in the local plan making process will know, most of us, we retire before the local plans get made. It's a really painful, torturous process. I'm working with some clients now in relation to the North Hearts local plan. That's been 10 years in the making. It's under the 2012 National Planning Policy Framework. And those are really serious concerns, because if it takes 10 years to get a plan, I think most communities would wonder whether that plan is still fit for, purpose when it finally gets adopted 10 years later. So I'll come on to that, because I think I did another slide about those particular provisions. And I know that just before we got started, somebody was talking about the local plan context. There's also going to be changes in the strategic environmental assessment and the EIA regime, and the introduction of what more? Environmental outcome report. So there's a lot of measuring going on. That is something that happens anyway through the SCA and the EIA regime. So, I guess we'll have to see whether those changes make a material difference, good or bad. And finally, I just mentioned it, there's going to be some changes to the protection for heritage assets. I'm not going to major on that today, but that is one of the things coming through the Levelling Up Bill. So on plans, 30 months. I just think that's totally unrealistic. it takes 30 months for the council to get a Reg 18 plan out. So I don't know how they're going to plan to do that. They talk down here about local plan commissioners being deployed to take over the plan making because it's taking things such a long time. There would probably be a lot of communities that would be anxious about having somebody parachuted in to produce a local plan for their community. This is another big change. I don't know if those of you listening know about the duty to cooperate with adjoining authorities. So I first bumped into this in a big way, both in North Hearts because they have to deal with the Luton's unmet housing need, but also in Coventry, unmet housing need for the rugby plan. And it happens in Wealden. It happens across the country where very large conurbations simply don't have the space to meet their housing need, and under the duty to cooperate, adjoining authorities have to, and have a burden, have to demonstrate that they have met that need. It's proven ineffective, and it was raised in the white paper on the environment, whenever that white paper was, I can't remember now, time frame, that this is just an unworkable requirement. And so now they're going to revert to what those of us who have been around a while know as regional strategies by the introduction of something called a joint spatial development strategy, and it'll cover planning, waste, and minerals. So a kind of reversion back to a more regional look at planning rather than the 5-year housing and being in the unmet housing need. I mentioned about removing the 5-year housing requirement, and this is the requirement to have up-to-date plans. And then another thing that we've just bumped up against in one of my cases, you have a SPD, which might be adopted by the council to guide the development of a particular side of a particular part of a local authority's area. But these don't normally go through an examination, so they don't have development plan status. They're guidance and their material considerations, but they're not part of the local plan. The Levelling Up Bill intends to make these SPDs carry more weight and potentially give them development plan status. Now, I mean, that can be good if you can influence your SPD that affects you, but it could also mean, in one instance where I'm involved in, the developers are bankrolling the making of the SPD. So you can imagine that the communities are quite concerned that those would be then elevated to the level of a plan document. And the reason that's important is under section 38(6) of the Planning and Compulsory Purchase Act, the council has to make a planning decision in accordance with the local plan. And if the local plan, the suite of documents includes these SPDs, it gives them the status of basically being a planning policy, where before they were material considerations. So it's big change there, little words, but big change. And then sorry,
Lisa, would you just say what SPD stands for?
Supplementary planning document, sorry.
Thanks.
So these commissioners, I don't know much about these commissioners. I don't know whether they would come through PINs, whether they would be effectively planning inspectors who work as commissioners. Maybe it would be a good thing. But in the North Hearts case, the planning inspector has been 2 years in reporting on the plan after the last hearing. So I don't know. I don't know how the local plan commissioners will, make a step change in the delivery of local plans. I think it's something to watch and be aware of. So one of the other things that the Levelling Up Bill does is it changes that section 38(6) duty that I just mentioned about the way planning matters are decided, to make clear that they have to be determined in accordance with the development plan and these new national development policies that I mentioned earlier. And the other thing that might alarm you, I think it certainly alarmed many people participating in the debate on the bill in June. Again, if you read the transcript, you'll see it proposes resolving the conflict between development plans in favor of the national policies. And there was quite a lot of debate, and Gove was asked to respond whether this is in fact a means of wrestling away local powers rather than restoring local powers. So I think there was a pretty genuine concern that the Levelling Up Bill may make some changes that don't necessarily favor local communities or empowering local communities. This other couple of provisions. Infrastructure levy, Gove said it's a place to place an inescapable obligation on developers to ensure they can make contributions that local people can use to provide services to strengthen their communities. Retain Section 106 for major developments. But one thing that I think is good, I don't want to give the impression that it's all negative. One thing I thought was extremely interesting was that there is discussion about ensuring that affordable housing is not challenged by developers putting forward viability assessments that show they can't provide their full quota of affordable housing, or indeed any affordable housing. So that again could be a very welcome change to force the developers to stick to the council's affordable housing targets. And then one of the other provisions that was in the Levelling Up bill was the treatment of wastewater. And I'm just going to touch on that very briefly about the stormwater plan that was adopted by DEFRA in August 2022. So the Levelling Up bill, I didn't get anywhere into a lot of the other detail. I just looked at the bit that dealt with planning and some of the environmental changes. It's a big piece of legislation, and I'm sure people have lots more to say on it and much more detail than I can offer you in a short Zoom call this evening. On this storm flow discharge plan, this was published by DEFRA. You can find it on the link, and it has its mission. Its mission is to deal with what has been brought to a head by a summer, or it's been years worth, but this summer's repetitive discharges of massive amounts of untreated sewage into the rivers. And so again, very, very important objective, but I think there is some concern, and I don't know if you as a group looking after your river or dealing with rivers in your catchment are worried about this plan, have read it, have similar concerns to certain environmental groups that we know have concerns about it. It introduces some targets, again, a lot of talking shop. Headline target: water companies will only be permitted to discharge water where they can demonstrate there's no local adverse impact. That sounds really good. Water companies must significantly reduce harmful pathogens, to help clear up bathing waters. That all sounds good. They have to ensure that storm overflows operate only in unseasonably heavy rainfall. Look at the deadline though. Storm overflows will not be permitted to discharge above an average of 10 rainfall events per year, 2050. So I think the commentary that we've had discussions with a couple of groups is it's really the time frame for the implementation of these important targets. It's the time frame is not at all going to meet the problem for generations, really. If you're talking about a target of 2050, and I think we're 2022, that's an awful long time to continue to have the problems. The first target I talked to you about was the protecting the environment target. That's, they have to achieve 75% by 2035, 100% by 2045 for priority sites, and 100% for the rest of the sites by 2050. Oh, is that my microphone doing that? Oh. Anyway, the targets have been criticized as the plan is really not doing enough to sort out the priority sites in the period between now, 2022 and 2035. And I know that there are certain environmental organizations that are considering judicial review of the plan as in breach of other legislation. So, we get the document, and then when it's digested, there's a genuine concern whether it's actually going to deliver a meaningful improvement in the environmental context it's been drafted for. There are also these changes to the SCA and EIA regime, and I don't know, again, if your group gets involved in reviewing EIAs, you may well do, or SCAs if it's related to plan making legislation. So these bring what is dubbed reporting requirements to make it more results-based, with a new reporting regime called the Environmental Outcomes Report. At the moment, we have something called an environmental statement or an environmental impact assessment report. the outcomes will be set by the government based on a framework derived from, here we go, the Environment Act 2021 and the 25-year plan. But we need somebody like Teresa Coffey to pull her, to step up to the plate and put her legislation on the table as to what those targets will be. There's a particular reference to integration into the biodiversity net gain into the planning system. And I think it follows and is similar to the current system we have, where the EIA regime is only in play when a project is likely to have significant environmental effects. So it maintains the structure, but it's kind of changing the reporting. I mean, that might be a good thing. I think we'll have to see how they work in practice. So just quickly, I don't think I'm going to go all the way through this now for time reasons, but this environmental outcome report follows a stepwise process. And this is a stepwise process that we're familiar with. Assess the harm, assess the mitigation, and determine whether the do nothing scenario is feasible. You know, it's not dissimilar from the system we're in. But what I think here is the key is how good this works is what exactly will the Secretary of State say that the standards have to be? What are these outcomes? How high will the bar be set to determine whether this is going to be an effective change, a meaningful change? And then just briefly, for those of you that are interested in the heritage environment, there are some provisions in the Levelling Up Bill that deal with changes to how you assess impact on heritage assets. And part of what it does is it expands the definition to spell out includes ancient monuments, world heritage sites, registered parks and gardens. And we were involved in a case involving the Jolly Boatman case, and I think it's a bit worrying. Some of these changes might be a bit retrograde. Introducing a test of preserve or enhance. That word "or" is a bit worrying there, because preserve, we all understand what preserve means. That means you don't change the setting, you preserve it in its historic state. Enhance can mean what the inspector in the Jolly Boatman case said was, it doesn't, I'm just paraphrasing, but this is what he said. It doesn't preserve the setting, it makes it better. So there's not an adverse impact. And the Historic Parks and Gardens, who gave evidence to the inspector and other local community groups, this is Jolly Boatman, is in relation to a setting on the housing development on a site opposite Hampton Court Palace. You can read the appeal decision. You know, they just disagreed. They in Historic England said there would be harm to the setting. But the inspector took the view, well, actually, I think it enhances the setting because it's a bit of a rundown piece of land. It's a bit scrappy. So that test of preserving or enhancing could shift away from maintaining the setting to allowing nice little drawings to look like it's going to enhance the setting to be a basis for saying there's no heritage harm. I don't know if I can, maybe before I send the slides around, Sue, I'll put the inspector's decision down and the pre-action letter that Elmbridge sent, if I can get their permission. Oh no, they brought a claim. I can probably get the grounds to why they felt the inspector had erred in his view of preserve and enhance. Right, so I'm sure, I don't know, I can't see everybody because I've put my, but I'm sure there's people out there who have a lot of experience with the biodiversity net gain calculator, what it is and how it does. There is some framework in play already through the National Planning Policy Framework and for both planning decisions and also for plans. There's also National Planning Policy Guidance that brings in this concept of a biodiversity net gain. And then there's Natural England guidance on what it is. That was the good news. The bad news is that these current framework for the concept of a biodiversity net gain doesn't set a percentage. And there is some case law and inspectors' decisions that says 1% would be a gain, because how can you argue that isn't 1% is better than 0%? So I think there is a concern that the Environment Act it requires this secondary legislation to be implemented, and that the 10% biodiversity net gain that's in the Act is not yet in law. And there is no, unless Paul's going to tell me I'm wrong, there is no yet secondary legislation, and things are not, in my view, not looking likely given the ministerial statement that Therese Coffey I mentioned earlier. So it's there to be implemented, but it needs secondary legislation to make it into law. I work very closely with an ecologist from Bioscan, who is happy to see the biodiversity net gain calculator in practice, but is also worried whether they just become a quick means of arguing that there isn't biodiversity harm. And I'm just going to read this very quickly. It's an extract from a letter that he sent on a matter that's on my desk at the moment. So the Environment Act includes provisions requiring new development achieves 10% net biodiversity gain, although this is not yet enshrined in law. That's what I've just told you. Some councils already have adopted 10% biodiversity net gain policies. Some even stipulate 20%. The performance of a development project against this target is assessed using a standard metric. And I don't know how this is done. I'm not an ecologist. On sites such as this, we more often than not find that the figures are fiddled. This is a direct quote by developers to achieve the 10% or at least greater than 0%, and can be open to challenge on technical grounds. In this case, the description of the grassland sits incongruously with what you've stated about its quality, the presence of certain species indicators such as cowslip that suggest that it may be undervalued for its grassland value. An independent assessment might, if it finds the grassland to be much better than the developer is presenting, establish grounds to challenge the compliance with the provisions or the 10% net biodiversity gain threshold. We've done this with some success for several action groups. I think if you come into a situation where you want to challenge a developer's calculation on biodiversity net gain. Oh, sorry, so look, there's still one BG in there. I'm sorry, I thought I corrected them. Anyway, go and get an ecologist. This isn't a legal issue. Go and get a good ecologist who can really unpick what the developer has said the baseline is and the basis for calculating the gain. That's my suggestion to you. Don't run off to your lawyers and say, we don't like the way they're doing it. Go and get an ecologist that can point to flaws in the way it's being applied. So this is a case study in Oxford. That is the site. It's a little site, but I thought it was remarkable to me that the net gain calculator would really even be in action in such a dense city space. That's the little sliver of land that you saw on that slide. And the development was the demolition of these garages and the development of 3 dwellings, 2 1-bed and 1 2-bed. And a local ecologist subjected to the way the development was applied. Sorry, the metric was applied, and he calculated there would be a 91% loss. And he said, even if you apply a different form of metric suited to urban areas, it would fail to meet acceptable policy standards for Oxford. The consent was granted with a condition to basically engage with a biodiversity net gain calculator. This is what the condition says. That's that strip of land. That's the development plan. That's the red line boundary for those of you that know that technical word. And one of the things that's important is sometimes these biodiversity net gain calculators leave out to the condition stage how the improvements will take shape in the development, and that can cut out public participation, because generally the public have no legal right to be consulted on, and you kind of have to force your way into being consulted on how conditions are discharged, which is what this ecologist did in this particular case. And he objected to the discharge of the condition. He said that the proposal to put swift boxes won't work, and the landscaping is on land that's not owned by the developer. and the rest of it would be in private gardens with no ongoing control as to how it would happen, or what would happen to those biodiversity enhancement measures after occupation. So he was pretty damning of the way the biodiversity net gain can work in practice. I don't think it is all doom and gloom, but I think you have to certainly engage with your experts when you are faced with a question of whether the biodiversity net gain calculator is being used effectively. I've got a few more minutes. I'm not going to be much longer. This is this retained EU law revocation and reform bill that I mentioned, sometimes known as the sunset of retained law. The explanatory note says the purpose of the bill is to provide the government with all the required provisions that will allow for the amendment of retained EU law and remove the special features it has in the EU, in the UK legal system. The reforms were announced in the Queen's speech in May. And then it goes on to say in explanatory notes, the bill will give effect to policies that were set out for the benefits of the Brexit report. So all of what we're looking at now is a direct consequence of Brexit. This is not a conversation about Brexit, but this is what's happening as a consequence. Okay. I can't see all of that. Why can't I see? Oh, let's go back. So sometimes it's known as the sunset clause. It'll repeal EU legislation by the end of 2023. It'll repeal the supremacy of EU law from the UK law. It'll facilitate domestic courts departing from retained case law. That should scare you, because there are some very good decisions that provide strong environmental protections. And if the domestic courts can turn their backs on that case law, it provides a hole potentially. I won't read all of these, but I suggest that you should go to the bill and look at it and see for yourself what is coming, because it doesn't make you feel very warm and comfortable, especially given the fact that the substitutes, the Environment Act and the standards and the targets aren't moving apace. I mean, these things have to happen in lockstep if they're to retain some environmental protection. And finally, this was a case you may have come across, you may have read about it in the press, Harris versus the Environment Agency and Natural England. Natural England wasn't a direct defendant, they were an interested party in the case. We weren't involved in the case. The claimants argued that water abstraction in the Norfolk Broads was causing irremediable damage to the environment, including legally protected ecosystems, which are protected importantly under EU legislation. The judgment against EA was engaging the EU habitats law on the finding that the Environment Agency is effectively and certainly the principal public body responsible for determining water abstraction licenses, whether they should be granted, invaried, or revoked. And if it doesn't do its job, then there's no other body capable of doing that job. The judgment held that the EA must take appropriate steps to ensure that the special area of conservation, that's an EU designation, there's no possibility of deterioration of protected habitats or deterioration of species as a result of licensed water abstraction. And in the judgment, I think I can get, I've given you the case citation, you can just Google it, you'll pull it up on Bailey. In his judgment, Mr. Johnson held that the Environment Agency had acted unlawfully by limiting its investigation into the impact of 3 sites rather than the broader water body, and its refusal to consider the effects on the entire SAC had breached the obligations of the directive. And I think importantly at the moment, it reinforced the fact that the Article 6 of the Habitats Directive remains enforceable in UK courts, notwithstanding Brexit. But you know, we've got the repeal of EU retained law coming, so there could be some changes pretty fast if that happens. Then there was a hand down on the remedy. In other words, the case was bifurcated. They had a decision on the substantive legal issue, whether there was an error by the Environment Agency in its actions, and then there had to be a remedy. Written submissions were made to the judge, and this is what so I think it'd be quite interesting to see what comes forward from the Environment Agency on the 7th of December. Those of you that have followed the Client Earth legislation on air quality will know that often courts set targets for environmental bodies or DEFRA to respond to, and they don't make those targets, so they don't do what they should be doing. But anyway, the judge here said that the Environment Agency has until 4 p.m. on the 7th of December to provide the claimants details of the measures it intends to take to comply with the Habitats Directive, and shall include an indication of the time frame for which the defendant has to completed those measures, technical basis for the measures. So it's good because it means at the moment, and maybe that's one of the takeaways from what I've learned myself in preparing for your talk this evening, is that so long as the EU legislation, if they can't get their act together to repeal it, and they don't have the wherewithal to get the other legislation in play, that we still have the EU law to rely on, and this case tells us that for the moment. And finally, my thank you to having me tonight, and any questions or discussion that you'd like to come back to me on, and I'll stop sharing so we can see each other and chat for a bit.
Thank you very much, Lisa. That's a lot of information to take in, and I think there's some interesting and important things there that we can use once we've studied it more. I haven't seen really questions in the chat, but there's lots of exchange of information, which is really useful. Omi Ambaba has a question. So I've asked people to put their hands up. So have I got your name right, Omi? You'll have to.
He needs his mic on.
Oh, or Prem. Is it Prem?
Can you, maybe Omi, yes. You've unmuted now.
Thank you. I'm sorry about that. I converse with my granddaughter in Australia, and Omi is German for grandmother and Bawaji Indian for granddad. So I'm sorry about that. The question I have is I live in a little village called Helpston, and we've got a massive residential-led development happening here, which is Peterborough is one of those 39%, I guess, of areas that do have a local plan. They put it in place in 2019, and we rushed through a neighborhood plan, which is, I guess, the next level down, and we had that accepted by the council a little while ago. We did that in about 9 months. That was quite good work. However, it seems that the developers can basically they don't have to pay very much attention, from what I gather, to the local plan. They are being, although we're quoting in our objections a lot of objections to the local plan. For instance, one of them is biodiversity, and what they're turning around is saying, yes, but you know, we're not going to do anything in your village, but we are going to do something in a site that's 20 miles away. And it seems to be that a developer can still walk roughshod over local plans, and I just don't know how much power they actually have. That's honestly, Lisa, I was wondering whether you had any comments on that.
It's quite hard to, I need to dissect that a little bit. So is this a planning application made for a planning allocation? So the site is allocated for development? Correct.
The site was allocated for development in 2016. The local plan was put together in 2019, and the developers have just a few weeks ago submitted their final plans.
Okay, so the planning application is made in accordance with the planning allocation. The planning allocation for this site says you can have 300 houses or whatever
it says 82, but they're going to be putting in about 130. But
so it's not in accordance with the allocation.
I guess no, to the letter of the no.
No, it's not. It's definitely not. If the allocation is 82, the site is suitable for 82 dwellings. That will be what the inspector examined in terms of soundness and the suitability of the site for that capacity. if the developers put in an application for whatever they wrote, like 182 or 132, then it's not in accordance with the local plan. It's a departure from the plan, and the council will have to determine it as a departure from the local plan.
Right. So what they're arguing is that on the local plan, it said anticipated number of houses as opposed to number of houses. so they're kind of saying, well, that's the anticipated number.
That's the wiggle room. I've seen clauses like this where there's a kind of plus or minus. In other words, it's not a set figure. I think there's a matter on my desk. I probably shouldn't go into the detail, but there's a similar, what is the plus or minus?
Right. Right.
I mean, if you want to give me a call separately, I'm quite happy to go into the detail, but I'd need to look at the way the policy is drafted, look at the inspector's report on the policy, look at the planning statement that supports the planning application, and understand how the developer thinks, using your words, they can walk all over the local plan.
Sure. What about the biodiversity thing? I mean, we have children in this village, we live in this village, we have beautiful countryside around us. They're going to fill up that bit of land with concrete and brick, which will probably fall down, you know, before a bit of lettuce goes wrong. But they'll build that, and then they're going to put the biodiversity gain 20 miles away. Is that?
Well, yeah, because I think in my slides you'll see that it was anticipated that the compensation can be off-site. I don't think it always has to be on site.
Okay.
I think you're right to be alarmed at that. And I think you would do well. I'm just going to say this, so I don't want to sound like a broken record. You want to fight that planning application. You get an ecologist to say that what they're proposing is not a suitable biodiversity gain improvement. Off-site improvements should not be the way forward. It should not be led by removing the requirement to have the biodiversity gain on the site.
Yeah.
Turn it into a test case. If you've got a good case, turn it into a test case on that principle.
A bit braver than I am, but I'll hand over to someone else, Lisa. Thank you very much indeed.
Thanks, Prem. Teresa, you have a question. Teresa?
Sorry, hello. Sorry, I had to unmute and everything. I didn't expect to be next. Thank you very much for all that, but I'm a bit overwhelmed. But there are two issues. I belong to the Thetford Environmental Group, so I live in Thetford. We've got 5,000 new homes. The infrastructure, what prompted me, someone in the chat was talking about infrastructure. So what recourse as a group, or what law would we use, who should we approach to get them to do something about our existing infrastructure? Because our existing infrastructure for storm water isn't working. And now there's going to be another 5,000 houses. And the sewerage works is not up to scratch. It's only for 30,000 people, and we're way beyond that. So that's one question. How would we even begin with that? And the second thing is loads and loads and loads of ancient, well, not about ancient, but veteran trees were taken down with the 5,000 houses were prepared, the land was prepared for it. What recourse do we actually have to get them to do something about, you know, compensation for that?
I'll have to ask you the same question. Is this a allocated site for 5,000 houses? It's been adopted in the plan. Who's the local authority?
I suppose that's Breckland.
Is it
Breckland?
I know Breckland.
We're so it's so complicated here because we don't even ever know which council to approach. Is it Norfolk? Is it Breckland? Is it Thetford?
If it's an allocated site, so it's part of the Breckland plan, it's gone through examination, the plan's been adopted, that allocation is a recognition that the principle of development on that site is appropriate. That's that section 38.6 duty that I kind of paced through. Section 38.6 duty says that when a planning application comes forward, Breckland, as a local planning authority, has to determine the application in accordance with the local plan, e.g. that allocation for development of that land, unless, and this is important for you, material circumstances dictate otherwise. So the allocation sets the principle of development, but the inability to resolve the stormwater drainage or deal with other infrastructure or to deal with transport can be a basis. It's an uphill climb. It's an Everest uphill climb. It's not easy to argue that even though the site is allocated and even though the policy is in play, there are material considerations such as transport harm, stormwater runoff, flooding that cannot be overcome through this particular planning application. So you kind of slightly start with, you're in a hole because you've got the site allocated. So you have to find and provide very credible evidence when you're fighting the planning applications to show that there are material reasons why the decision should be, this particular planning application should be refused.
So have we got any recourse for them to improve our existing infrastructure? Like the drain, we've been told the drains are old, there's nothing we can do.
Yeah.
And so we have sanitary products all over our park whenever there's a major storm.
If you have some facts that fit into the Harris case that I covered at the end about dealing with harm to EU designated sites. I don't know in Thetford if there's any EU designated sites that would come into play or any triple SIs. You might be able to basically argue that, well, first of all, they need to carry out a habitats regulation assessment, because at the moment that still is the framework in play, to show that the development would not harm the habitat or the species of those designated sites. But again, I would say, Teresa, I would say, go and get an ecologist. Don't come to your lawyers, first of all. Go and get an ecologist to assess what are the protected features, either on the site, because it's big if it's 5,000, or within a kind of spatial context, that you could argue that the lack of proper sewage and drainage would tip polluted waters into sensitive sites. You can use that as an argument to oppose the planning application, but you need the facts from a skilled ecologist that can assess using something called the MAGIC data that shows what sites are within the proximity or on the development site or in proximity of the site. Go and get a good ecologist when you're concerned about those issues, or get a drainage engineer. I mean, one of the best things my clients do when they're fighting planning applications is they arm themselves with a team of experts that can argue coherently in front of planning committees that there are serious environmental harms that have not been identified by all of the developers supporting information. Because you'll see there'll be an environmental statement for a site that big. You need somebody to pick apart that environmental statement and say, actually, they haven't considered this, or they haven't looked at this impact, or they haven't planned for how that mitigation measure may not work. Okay.
Thank you very much. Thank you.
Yeah.
Anyone?
Did you notice Helen Booth is trying to ask a question soon? Maybe.
Yeah, I can see that, but just before asking Helen, I was going to say, if anyone on the call knows of reliable sound ecologists or drainage engineers or anyone else who might be able to help, perhaps you could put a name or a contact there that would be helpful to others. That might be helpful.
I mean, I would highly recommend, and I'm not getting a commission, I would highly recommend that you go to Bioscan. I use Bioscan whenever I can. They work nationally, and they have incredibly skilled ecologists. And you don't need the top dog, you don't need Dominic Whitfield. There's a number of the junior ecologists that are quite senior in their own right that work with Dominic. So that would be a really good resource for you to make contact with and contact them. And they are good, they write clearly, they get their point across, and they're able to tackle not only what the planning applicant may say in his or her supporting information on ecology, but also to tackle any oversight by the planning officers as well. So when the council's when the council's ecologist is evaluating it, puts the council ecology consultation response on the planning portal, you've got somebody like Bioscan being able to say to the planning team, you've missed some important features here. I've seen applications refused because of bioscan's input into the planning process. Okay. I'm not saying there aren't others, but that's the group that I would go to in every instance. And I mean, they'll be rarely will they be conflicted, but put them on your, go-to list.
Thank you. Helen Boothman.
Right, well, thanks ever so much, Lisa. It was just building on your response to Teresa, but coming down from EU. And it was just a quick question on what weight do county wildlife sites have in planning, and especially when the county wildlife site designation is given to a river. And secondly, it was just asking, are you aware of other effective conservation measures coming down the line? And also, what weight do you think they will have in planning terms? Thank you.
In terms of a county wildlife site, the last time I looked at it, and I'd probably like to go back and just read the NPPF, and maybe Hannah or Paul can quickly check if there's anything in the NPPF about it. What we did when we were looking at a county wildlife site is we looked at the species mix. We identified the species that were involved, or the habitats that were involved, rather than just saying, oh, it's the designation that matters. Because they're not given the same level of protections. You don't have to carry out a habitats regulation assessment in relation to a county wildlife site, but there will be a material planning consideration in any determination. But what's important is to get across what is the value of that, what's the ecological value of that site, especially if you've got a council policy in play where they have already adopted a biodiversity net gain percentage. So obviously a county designated wildlife site will have a lot of value. It should have quite an important value. And if it's at risk or is threatened with impacts of adjoining development, you'll be able to show that development will harm that biodiversity and show a decrease in the biodiversity delivery. So I would look very, very closely at what the species are, what the habitat is, and see if there's a council policy in play that has already, as a council policy, adopted a biodiversity gain target, and use the value of that site to argue that the council's policy on biodiversity gain is not being met. That's how I would do it.
Thank you. Jean Glasberg.
Hi, yeah, thank you very much, Lisa. That was really interesting. Hannah from your company has already been helping us a lot with Paradise Nature Reserve, which is threatened by the development of Queen's College student accommodation right next to it. It is a city and county wildlife site, and there are 16 policies that we've identified in the local plan that this does seem to go completely against. But it doesn't seem that the council officers have really taken great notice of this. And we've obviously bioscan, again, I'd really support what you said about bioscan, because Jeff Moxon from there has really helped us a lot with that. But I just wonder, what is it that determines whether a project has significant environmental, whether something is going to have a significant environmental impact or not? Because there hasn't been, I mean, this is the major problem that happened with this, is that there was really no environmental impact assessment beforehand.
So just Hannah's on the call. Hannah can talk to you. Where's Hannah?
Yeah, Hannah's on the case.
She's on the call. Can't she answer this question? Or maybe she's gone.
I mean, this is really more a general question about why in this case was it not considered important to have any kind of environmental impact assessment? Because
well, okay, so let's yeah, okay, so you do have to carry out an environmental or an ecology assessment. Normally these are known as phase 1 habitats assessments, okay?
Yes. Yeah.
If it then will have impacts on an EU designated site, you have to carry out something called a habitats regulation assessment. So it's 2 tiers. The top tier, the HRA, is done for EU designated sites, special areas of conservation, SPAs and Ramsar sites. If your site doesn't get to that, say, designation status, still there's an ecology impact and they have to carry out an ecology report. And I would imagine that Jeff would have assessed what the ecology report proposed.
He has.
And
His report is completely damning of it.
yeah,
I mean, there are
and
8 species of bats, including a barbastelle.
yeah,
So it's high suitability for bats, but they are proposing to fell the corridor of trees that is the bats' foraging.
but they'll need okay, so Jeff will have told you they need a license to fell bat habitats. They'll need a European protected species license from Natural England. Natural England may have given a consultation response as to whether they were content with that felling.
But I think no, because this was decided. This is the problem, the fact that there was no proper environmental assessment beforehand. The decision to fell the trees was taken early on in a pre-app meeting by the tree officer to facilitate the drainage scheme. Because it's in a flood area, that has also now been comprehensively dammed by a hydrologist. But the whole process basically has been the wrong way round. Because there was no environmental assessment initially.
So where are you at the planning stage? Has it been resolved to be approved, or has it been?
No, it's at the stage where obviously there's a lot of objections. There's over 200 objections, and there's a petition that's been signed by over 2,000 people. But it's supposed to be going to the planning committee on the 7th of December. And we're just waiting to hear now whether it is going to go to the committee and whether the officers are going to be recommending approval or not.
Yeah, well, fortunately, you can lobby your local councillors to refuse it over the officer recommendation. You need to carry your political stick as well as your kind of.
Yeah. Oh no, all our local councillors do support it.
They support it. They want to see it happen.
No, they don't. They're supporting us. Yeah, sorry.
Okay, well, at the planning committee meeting, there will be, you will be able to address the planning committee in your 3-minute slot.
Yeah.
You have an opportunity for the councillors who will make that final vote decision to refuse it on ecology grounds. The councillors carry the ultimate decision making. That is where you need to put your efforts between now and when it goes to committee, is to make sure that you have the numbers that if the officer does recommend refusal, the committee members will refuse it over the officer recommendation.
But then the college is very likely to go to appeal. And I think that councils are very nervous of particularly colleges and the university because they have plenty of money to do this.
Well, I don't know what to say other than you have to plan to attend that planning inquiry as a Rule 6 party. You get Jeff there and you give your evidence to the planning inspector that the committee was right to refuse it on environmental concerns because it's a sensitive environmental site.
Would that mean going to judicial review on it though?
No. So the fork in the road is if it's approved, then you take judicial review proceedings.
Yes.
If it's refused, the developer goes to the planning inspector and it's determined to
appeal. Yeah. Okay.
Okay.
Thank you.
So it is really, if you've got your evidence base in to give the councillors good reason to refuse it.
Yeah.
And you've fed them proper information through sending them copies of the bioscan report and making sure that bioscan has identified the material harms as a result of the development.
Yeah.
Give those councillors that ammunition at that meeting and get a refusal through the councillors, even if the officer recommends approval.
Okay.
I understand, it may be quite hard for a planning officer to recommend refusal of a college application. I get that.
Yeah.
But ultimately, the councillors make the decision.
Yeah.
And as long as they've got good facts, it's very, very difficult when the councillors feel they want to support you, but they don't have the grounds to support you. They need the grounds to support you.
Well, Helen, that's where Hannah has really helped us. I mean, she's got us consultants who have given good evidence that this should be refused. But it is difficult. I mean, I think the fact that the university is funding the planning service is one of the things that is quite worrying, and that makes people feel unconfident about, you know, the officer's impartiality on this.
Well, the officers and the planning authority, should you go to judicial review, if it's approved, they will be under a special level of scrutiny if there's any where there's a link between the applicant and the deciding authority. Okay.
Mm-hmm. Yeah. Okay. Thank you.
Yeah, but I would get your councillors out on the site, get them in their wellies, get them walking around, really make them understand the site, because it's, you know, it's quite dry stuff planning when you've probably attended many planning committee meetings and you've seen the way the officer feeds it through, and there's all these nice little drawings and it all looks fine. It's a lot of green. Yeah.
Yeah. Yeah.
Your councillors have the ultimate say.
Yeah. Thank you.
But that would be my if you've got your college, use it, deploy it with your councillors now.
Okay. Thank you. We will.
Thank you. Any other questions? Yes, you have iPad on the person who's called iPad. I'm sorry, I don't remember your name from earlier. You have to unmute.
Fine.
Yeah.
Can you hear me?
Yes.
I just wanted to ask a question. On the site that's got allocation, the developers are proposing what was originally called a balancing lagoon, but which is now being called an attenuation or whatever. I've not got a thing in front of me, but attenuation sort of water system. But it was a balancing lagoon, and it was going to be next to a public open space, and it's not going to be fenced off. And then you've got all the houses, and they were talking about putting landscaping, trees and so on. I just wondered if anybody's come across balancing lagoons, public open spaces next to them, and the arguments that you can use to oppose the actual application. And
yes, we have.
Well, who takes them over eventually? It's the water authority. If the water authority doesn't want to, the parish council won't want to. There's one council near Northampton, about 14 years later, still not getting anywhere with this particular developer to take over the responsibility, which they themselves actually want to take over. Our own council wouldn't want to take that over. Any information or questions or answers about that would be helpful.
We've come across these types of lagoons near houses, and one of the big arguments, one of the best arguments to make is their safety
For children.
For small children. They're totally unsafe, and they really should be fenced off. And so therefore all the arguments about, oh, we're going to make it into a nice place to walk and the rest of it is just nonsense. And so you know, and don't forget, this sounds a little bit cynical, but our society considers children as having very high value, and they don't want to damage them.
Yes.
And so that's quite an emotional argument for you to put, and we've successfully done it in the past.
Yes, they're not supposed to grow vegetation, are they? Because children can, you know, it's all to do with rolling down the hill. They say there won't be any water in it, but the site in the past has been flooded. So,
well, if it's a balancing pond, it will have vegetation in it because it will have water in it because it's designed to hold water so that it only releases water into the drainage system at the existing rate of drainage. That's what they're designed for.
It's a big thing in the States. I've seen that. I've seen lots of stuff in the States about. But I just wondered why would change the name from balancing lagoon to attenuation pond or something like that.
Well, yeah, it's that's really just a nomenclature. I think.
Right.
Yeah, it's not.
Okay.
Alan.
I work with a really good drainage engineer. I'll ask him if there's any technical difference between an attenuation pond and a balancing pond. I mean, obviously, the basis for use of these water retention facilities is the hydrogeology of the land means that they can't absorb once the land is built on. They don't have the same absorption levels. I just went around the block in a Without Prejudice meeting with this engineer in tow. And where the hydrogeology of the land is unsuitable for natural absorption, they have to store the water somewhere. And then, as was mentioned, the water has to be released at the current rate. So, but I think, I might be wrong, but I think if you go to the Accordia development on Brooklands Avenue, you can walk around to the back and you'll see an attenuation pond. It's a very common, it's a very, very common means. But obviously the question of design and safety for those playing nearby has got to be paramount. I mean, I can't imagine a developer is going to be unwilling to deal with the safety issue.
What about the neighbour? Because we would back onto that exact area. At the moment, it's just farmland, and then we're going to be presented with a pond and a public open space area. We're just worried that it's just going to sort of vandalize the area, really, urbanize our overall village setting, really.
Well, I think, you know, you'll have to look at the landscape arrangements, because there'll be either a planning condition or they'll have a landscape strategy as part of the application, and look and see whether the landscape strategy is appropriate for the setting. That the balancing ponds may be a feature in the landscaping, the overall landscaping.
Yeah.
We have three hands up now. So Alan, have you just taken your hand down?
I can make another comment if you like, but
no, that's Wendy.
Lisa, I wanted to ask you about, you referred to planning conditions. Often things are left to, to be dealt with by planning conditions. What about a situation where, part of the planning conditions are, it's like tree planting on a, there's something about, this protection of root protection zones, on a development site, or tree planting, etc. And it's very clear that, these are not being followed. What is the recourse on enforcement? Because that seems to be a very big issue in Cambridge.
Yeah, well, I came across this issue at Homerton College because there were some TPO trees that were going to be affected by the development there. And the most important thing to do is to establish whether you're dealing with a TPO tree or not. Because if you've got a TPO tree, then you have a much greater armory of argument that there should be a certain root protection zone. I dealt with a matter last month involving Elmbridge Council, where the clients, including several members of the community, were calling the planning officers on Sunday, getting a hold of their local councillors on Sunday, because the developer had brought in very heavy equipment allegedly for landscaping means. This was after a very significant demolition application. We managed to get it refused on heritage grounds. And I think there was a concern that the developer was intending to kind of denude the value of the site by some landscaping works, but was doing it in close proximity to some protected trees. So we sent in an awful lot of information and got the tree officer on the site within the week. It's really important to get your tree officer on the site and try to persuade the tree officer that what's going on is harmful to the trees in question.
Lisa, just as an aside, it's well known in Cambridge that the tree officer actually is based in Brittany.
Oh.
So it's a bit of an issue. You can't get, so like if there are planning conditions, there's been there's been a landscaping plan, rules have been drawn up, etc. And nobody's checking to see that these are being enforced. So the problem is, what can you do? Like, what can people do?
Well, then what you do is you make a complaint to the local government ombudsman that the council had an ineffective tree protection officer who's not in locus to deal with emergency matters. Now, we had the planning officer, the tree officer, somebody else get on site and identify whether what was going on was harmful to the tree. It wasn't exactly the answer we wanted, but at least we had the tree officer on site looking at what was going on and questioning and making a determination in that particular instance that a badger survey was going to have to be carried out, because the land was also thought to, through some submissions by Surrey Wildlife Trust, that there was a badger set on site. So it's really important to get the tree officers involved, or go to the local government ombudsman.
The local government ombudsman, but because the other issue is that people have highlighted the fact that the city council's got a very low record of any kind of enforcement.
Well, yeah,
there's been no enforcement.
It's
no
great.
enforcement cases, you know. So
Yeah.
it's clear that nobody is actually checking to see rules are being enforced.
I couldn't agree with you more. We probably get 15 or 20 calls a year where very serious breaches of conditions or breaches of TPOs, you know, development taking place within the REIT protection zone, or limbs being removed. And the councils are very light touch in terms of taking enforcement action. And unfortunately, for those of you that know this, it's not the case law that we have to work with, is whether it's the council can make a decision whether it's expedient to take enforcement. And the courts are very reluctant to engage on an argument that the council was erred in its decision, that it was not expedient to do so. But when I was involved in an enforcement matter last month, we went and got the council's enforcement policy out. Go and find the council's enforcement policy. Councils adopt enforcement policies and point the council planning officers to the relevant sections of the enforcement policy. Build your case that the council is not acting in accordance with its own adopted policy.
Thank you. That's really helpful.
Yeah, I'm afraid it is really a challenging situation if you can't get the local authority to take action where there's breach of conditions or impacts on TPOs.
Well, also, just to add to this, sorry, but information is that the tree officer has a private company that also has on the website saying that they can help the client get, because of their experience in local government, and help the client get the best outcome.
So you need to get your local councillors involved in this. Your local councillors need to bring a motion to the cabinet as to what's going on with the council's tree team. There needs to be, use your scrutiny powers as to what's going on before you go to the local government ombudsman. Go to the Scrutiny Oversight and Scrutiny Committee at Cambridge and see if you can get this tabled as an investigation as to what's going on with a tree officer that's not in situ. Because, I mean, it's natural that if something goes wrong with a tree, it can go wrong very quickly, and you need somebody who's in a position to respond quickly, not get on a ferry from Collingwood to Portsmouth and then get a train up to London and get a train to Cambridge. The tree can be gone by then.
Yes.
I would get it in front of your scrutiny committee first.
Yes.
And then take it up with the local government ombudsman. Make it a political, get the councillors to own the problem.
Sadly, I have done that, but I will try again. I have done that at the scrutiny committee.
And what, well, okay.
8 o'clock. Prem, is your question very quick?
Very
Have
quick.
to unmute.
No, so I will, there's an honest answer for you. No, I will defer it. Thank you.
Thank you for being honest. So, well, first of all, a big thank you to Lisa for joining us and for staying on and taking the questions. It's been really useful and informative. So thank you for that.
It's my pleasure. It's fun. It's nice to do it. It's nice to step out of the day-to-day work of, you know, a matter that's on your desk and kind of have a little local surgery, so to speak, on planning matters. And I mean, there's people here. I see at least 1 or 2 clients here, and they will know that, you know, when you're getting down to the nitty-gritty of dealing with a particular matter, you're focusing on that detail. It's quite enjoyable to kind of stand back and hear what the wider concerns are. And, you know, my takeaway from this is local plans were supposed to mean something, but they don't seem to be being followed. That's one of the concerns. You put your ecology responses in, and the council doesn't take it seriously. And you've got situations where actions are being taken and the enforcement team is either unwilling to act or is too far away to do so in a reasonable time frame. I mean, it's not easy being defenders of the public realm, really. I certainly do admire my clients, because you all commit innumerable number of hours unpaid and really work quite hard and pushing the snowball uphill, and it's really hard. And when you get a win, it's really important to celebrate it.